Are we live? I think we're live. I think we're up. Oh, we're back. Just finished part 6, going on to part 7. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. I don't know how many parts we're going to be, but we're going to keep going. We're going to keep looking. We're going to keep searching out these details and providing you guys with the means and the base understanding of how to get ready to operate as a trustee through a private express trust. This is not legal advice. We do not offer legal advice. This is for educational entertainment purposes only. If you are seeking legal advice, please reach out to your licensed attorney for your legal matters. With that being said, we just covered commerce in general. Now we're going to be talking about doing business. We're getting to the end of this. It says 77 pages, but it's a lot of the end of it is templates, which I'm not going to necessarily cover extensively. But I think some of these templates are a little bit outdated. But this information is not. And there's obviously there after this we're gonna dive in. I think we're gonna dive into the free business trust manual after this. It gives you a little bit more hands-on of if you're wanting to run a business out of a trust and what that may look like for you as well. That does not include PMAs. That does not include a 508c1 FBO. It doesn't include any of that. It's just a base. I want to do a business out of a trust, sort of thing. So, I'm this stuff is important, man. This stuff is important. It doesn't matter if you're in Nevada, if you're in New Mexico, if you're in Delaware, if you're in Pennsylvania, if you're in Minnesota, Wisconsin. Look across the country right now. There's a lot of crazy things going on right now. So handle your affairs. Operate through private express trust to protect yourself, your family, and your land and your assets because they will seize them. This is not this is not legal advice. But you look at what's going on right now. You do better. You would do well to serve yourself. To operate out of a private express trust, one at the minimum. But you know that one is just not enough, right? You never just stop at one. You can never, ever, ever stop at just one. Okay. Anyways, making a little joke there. Sorry. Doing business. As always, if you got any comments, post them in the comment section. I'll try to review them at the end of this. But let's get into this. Doing business. I don't know how long this part is going to go. Maybe this might part. Let's see. I don't think this part. Yeah, this part. Of course, I'm an idiot. You, we're gonna go. You know what? We're gonna be talking about a few things here. I might go back to a little bit of the last section in terms of what I'm coming across in this section and going more in definition so that we can clearly explain things. But let's go. Even though the private express trust is technically not a business trust, it is. Within the established meaning of the term, this in no way prevents or inhibits the trust from engaging in all manner of business the trustee is permitted to under the trust declaration or trust contract, and it need only obtain the franchise of a business license if it anticipates doing express business in the above described jurisdiction. That's not necessarily true either. The trust may operate a business, acquire a business, sell or otherwise dispose of its business, or even contract under the limited liability system and to become a taxable entity. The choice is yours. You know what? Since we got a little bit more time on this section, let's look it up. People versus Rose. It's saying you need to obtain a business license, but that's not necessarily true. Is that it? People versus Rose Supra. Yeah, this isn't it. This is talking about some molestation stuff. type in license. Lewd and lascivious acts, child. You're not gonna give it to us, are you? Okay, yeah, this isn't what we want. Sorry, guys. Moving on. 142. Okay, the trust may operate a business, acquire a business. Interesting. Acquire a business. Sell or otherwise dispose of its business, or even contract under the limited liability system and become a taxable entity. The choice is yours. The only thing which may bar the trust from conducting a particular kind of business in any certain jurisdiction is the public policy of that jurisdiction, regarding which it has been admitted most states have not passed upon the subject directly. 142. No state has ever made any attempt to prohibit express trust, i.e., impair their contract rights of persons sui juris. However, many states have attempted successfully to prohibit associations, the most notable being the Ohio Attorney General in State versus Ackerman, against C.F. Ackerman and 90 other persons who were transacting business of guarantee and accident insurance in the state under the name of the Guarantee and Accident Lloyds, New York. The Attorney General alleged that they were doing business without having complied with the laws of the state or receiving proper authority from the state to do business of that kind. The court found that because the defendants were acting under mere association as opposed to under declaration of trust, they were in association unlawfully exercising a franchise within the state, acting as a corporation therein without being legally incorporated. The court indirectly affirmed the well understood principle scarcely in need of restatement that express trust may engage in any manner of business allowed to individuals as a natural right. When we talk about individuals, we're not talking about the statutory definition, we're talking about private individuals. In fact, to restate this principle over and over again would be ostentatious. Chisholm versus Georgia, which is a really good case to read as well. So basically, so far what that's saying is there's more here, is like you gotta be careful, like obviously, like they're through code, since they're operating. Let me go and find it. Where did it say it? They weren't operating under a declaration of trust. They were operating as an association, not a private association. But since they were operating as a public association, essentially, and they were operating as an entity that that in a realm that did need a licensure to operate in, which life insurance you do. Yeah, that's something you definitely need. That they were basically unlawful. They weren't doing what they're supposed to be doing. They're going against the laws of that state and the codes as well. So, yeah. Okay, let's keep reading that. As public policy is a form of regulation, it should be noted in the case of Munn vs. Illinois, 94 U.S. 113, 126, and 1876, in which the court expounded on the principle of regulation. Because the trust is of private property and its business is private as well, the trust business is not affected with a public interest. It does not become affected with a public interest until the trustee participates on behalf of the trust in the unincorporated interstate banking association, obtains a business license or other franchise, contracts under it, or conducts the private business of the trust in a manner to make it of a public consequence and affect the 14th Amendment community at large. When, therefore, one devotes his property to a use in which the public has an interest, he, in effect, grants to the public an interest in that use and must submit to be controlled by the public policy to the extent of the interest he has then created. He may withdraw his grant by discontinuing the use, but so long as he maintains the use, he must submit the control. So basically, however far in the public you go is however far in the public you must listen. If you dip your toe in the pool a little bit, you ain't fully swimming. You jump in the deep end, you're with the sharks at that point. Does that make sense? Keeping that simple. So, like, say I start a business trust and I want to provide a service for some neighbors to cut their grass. I'm not really affecting many people in the public at that point, so I don't have to worry about a lot of statutory confinements. Let's say I start a business on Walmart as a reseller. Okay, well now I'm out there a lot actually. So now I gotta bring myself underneath some regulations there, if that makes sense, because I'm affecting the public more on a bigger scale, if that makes sense. So just understand that you can start a business out of a trust. You can use a trust to create a business, hold a business, buy a business, sell a business, etc., etc. But you just got to be mindful about how you basically intermingle with the public. Public versus private. Again, I've said it every single part of this read through. That is very vital. If you have any questions, shoot us a message on Instagram. If you want to know more about public versus private, we will gladly outline that for you. We will gladly outline that for you. It's not an issue to us. We're here to help. So just make sure you have that understanding. Continuing. Regardless of the nature of the business, there is a due notice rule which confers a duty upon the trustee under equity. The rule consists of two parts. The first is that he should sufficiently distinguish and represent the nature of the trust to the party with whom he is doing business. It is of the utmost importance, in the form of business contracts, that full disclosure be made on all letterheads, business cards, checks, bills, order blanks, paper, etc., so as to prevent any claims of lack of disclosure from arising in the future. Basically, let's say for whatever reason, like the person you're doing business with doesn't like you, or they decide not to like you after 6 months, and then they find out you're operating through a trust. Well, now they can take you to court and sue you for lack of full disclosure, and it's a void contract, a breach of contract, essentially, because you didn't come with, you didn't fully disclose everything. Hope that makes sense. I was gonna expound upon that, but I don't think I need to go further than that. Basically, just be very transparent. When it comes to business, you know. Let's keep going. But prudence dictates that a trustee must not disclose every fact regarding the trust, its declaration, and its affairs. You don't have to give that up. The first part of the due notice requirement can be sufficiently accomplished simply by employing the designations irrevocable, express trust organization, express trust organization, or organized under declaration of trust beneath or next to the trust's name. It must not be excessively revealing about the trust. The trustee has a duty to protect the privacy of the trust, but it also must not be misleading. The trustee has a duty to not compromise the integrity of the trust. He is in no way prohibited from exercising the utmost shrewdness, wise as serpents, harmless as doves. See McCoy Supra. The second part is that, I hope that makes sense. Basically, like, if you're gonna operate in the public, only give so much information. Keep the declaration and assets and everything of the trust as private as you possibly can. And when it needs to be public, and it can be public. The second part is that he should stipulate in plain and certain language in all written contracts and obligations that the trust only is liable for its obligations, and that neither the trustee nor interest holders are to be held to any personal liability in the contract. This is very important, because in general, when you're drafting your trust documents, we want to write that in there to begin with. Our beneficiaries are not subject to personal liability, nor are trustees. But when you step into the public a little bit, you have to kind of restate that, because you're in the private. You made that contract in the private, but we're not giving them all the provisions of that contract. So there's certain things that you may want to restate, if that makes sense. That will help you protect yourself when you decide to do business in the public. He may also wish to cite the provision of the trust which so limits his. So I got ahead of myself. So limits his and or the interest holder's liability, but this is often unnecessary. And the trustee should always designate his title either under or immediately next to his name or signature. We talked about this earlier. We're going to talk about it again. That's very important. 145. It has been suggested that whether the trustee designates his title or not, he is in fact acting as trustee because the substance, not the form, is what controls. However, for security purposes, I would argue that the designation should be applied in all situations regardless. Doing so will avoid any superficial confusion. Yes. I wouldn't even pay attention to this part. It's always form over substance for me. Form over substance. Always. I would always make sure you sign the right way, which we're going to talk about here in a second. The trustee should obtain a mailing address for the trust. And though he is the principal and holder of the trust property, it is generally prudent to refrain from mixing the trust affairs with his own. He should also obtain all separate business necessities, telephone, service, utilities, for the trust. Logic follows that he should do these things regardless of whether he is operating trust business or not. He should, for all intents and purposes, maintain a strict separation of the trust identity from his own. But one could also, this is not legal advice, this is informational and educational purposes only, one could create a trust named after themselves and then operate in commerce through it. And all of a sudden now you have, let your imagination go there. And that is perfectly legal. Sorry, perfectly lawful. And legal. Limiting liability and risk. Let's see what we at for time. We're a good time right now. We'll probably get liability and risk and then banking, and then we might end with banking. Ooh, yeah, transferring assets next time. And then issuing certificates in bond. Okay, yeah, we're getting to the end. We're almost done, guys. We might hit 9 parts. Yeah. And limiting liability and risk. In all contracts, as we have already noted, though it is best to always apply it, the trustee's mere designation of title is not sufficient to limit his liability or remove the risk to his own individual assets. Own nothing, control anything anyways, right? Instead, he must employ the proper language either within the term of the contract or above or beneath his signature, or in any proper place where it will appear unambiguously, meaning clearly, indicating something to the effect of the property and the funds of the trust organization only are liable for contract obligations. Individual trustees or interest holders are not personally liable. John W. Doe, acting as trustee under the Declaration of Trust, dated, etc., establishing the trust organization therein called ABC Trust and not individually. John Doe as trustee and not personally, as trustee but not personally, without recourse to trustee. Hold on. Me personally, I'm going to write. Do they have a pen app on this? Oh, baby. So, let me show you. That's my first name, middle name, colon, last name, comma, T. This is not legal advice. This is informational, educational purposes only. TTEE. That is trustee. And then underneath it, or next to it, or above it, all rights reserved without prejudice. I know it doesn't say that, but for sake of time, we're not writing all of that out. Just wanted to make sure you guys saw that. But that's how I would, every single thing. Every single one. Every single one. Every single one. There you go. Any forms. Sorry. Any forms. Why are we doing this? Thank you. No, I don't want to enter it. Here we go. I just had to start meddling, guys, didn't I? You guys gotta stop this. Apologies. This is the asset section. Come on. Alright. Here's what we're gonna do. We're just gonna refresh. Thank you. Any form of words that will convey in certain unmistakable language to the other party that he is dealing with an express trust is sufficient notice under the rule. Whether it is necessary to also cite the provision of the trust instrument which limits his liability is a decision left to the discretion of the trustee. To quote Mr. Justice Woods in the case of Taylor versus Mayo, if a trustee contracting for the benefit of a trust wants to protect himself from individual liability on the contract, he must stipulate that he is not to be personally liable, but that the other party is to look solely to the trust estate. And in the case of Shoe and Leather National Bank versus Dix, the court held, with regard to the promissory note made by the trustees under such limited liability, meaning under the promise to pay an obligation, a debt made by the trustees under such limited liability, that it was not within the power of the court to change the trust liability on the note into a personal one of the trustees. That liability on a contract must be determined by the terms of the contract itself, and that a contract entered into under such limited liability, be it a note, agreement, etc., cannot be converted into one under personal liability by law. To do so would be to alter the terms of the contract itself, which is a violation of what? Come on, wake up. It's a violation of what? Article 1, Section 10 of the Constitution of the United States. Probably one of the best, if not best, provision in all of the Constitution.
Amazing!
Make sure you remember that one. No state can pass any law or ordinance or anything that impairs the obligation of a contract. Furthermore, any such stipulation is ultimately subject to the acceptance of another party in order to gain validity in the contract. Okay, let's see what else we got. Alright, that's nothing. That's pretty much straightforward. So yeah, basically, you can do the method I showed, you can do the methods in here, or you can do the method that I showed plus some if you want to limit your liability. Just make sure you do it. Everything is a contract. If you are signing your name to something, your signature, your autograph, let's see if they got that word here. They might not, they might, it should. The handwriting of anyone, of course. And if not signature, we'll look at endorsement. Signature. In ecclesiastical law, the name of a sort of rescript without seal containing the supplication, the signature of the Pope or his delegate, and the grant of a pardon. In contracts, here we go. The act of writing one's name upon a deed, note, contract, or other instrument, either to identify or authenticate it, or to give its validity as one's own act. The name so written is also called a signature. It's important to like you're signing it. Yes. It's a I'm approving. Endorsement. Let's see what we got. This is the commercial term of it. The act of a payee, drawee, accommodation, endorser, or holder of a bill, note, check, or other negotiable instrument, and writing his name upon the back of the same, with or without further or qualifying words. Man! Whereby the property in the same is assigned and transferred to another. That which is so written upon the back of a negotiable instrument. One who writes his name upon a negotiable instrument, otherwise than as a maker or acceptor, then and delivers it with his name thereon to another person is called an endorser, and his act is called an endorsement. One of my favorites. No. This is so like me personally, and whenever I'm operating as a trustee and not as a personal, like whatever, I always want to be operating as a trustee, but for some reason, let's say I'm operating commerce as a secured party or as a creditor or anything. The only, like, I would never use the exact code from the Uniform Commercial Code because a judge or someone might be able to try to say, oh, that's you contracting underneath the jurisdiction. Well, I would disagree with that just from based off the fact that we have UCC 1-103, which we've visited this before, but where is it? It's to simplify, clarify, and modernize the law governing commercial transactions and to continue the expansion of commercial practices and to make the law uniform amongst jurisdictions. So one could argue, oh, okay, me using UCC 1-308 is not invoking your jurisdiction. I'm just trying to get you to understand the jurisdiction that I'm coming from. But I personally would not use it because they would try to say that, oh, well, you're using a code. But this is just all that, and this right here, this is codification of a constitutional right. That's all this is. UCC 1-308, formerly 1-207. A party that with explicit reservation of rights performs or promises performance or assents to performance in a manner demanded or offered by the other party does not thereby prejudice the rights reserved. Because a lot of people don't know what this means. Let's look it up. Without prejudice, without abandonment of claim, you're not abandoning your rights. You're not abandoning your privileges. You're not abandoning any applied admission of liability. Such words as what, without prejudice, under protest, or the like are sufficient. You reserve your rights. This is a big one. It's a huge one. Now, what's rights? It depends how you're coming. It really does. Because there's different rights in different jurisdictions. There's different benefits in different jurisdictions. There's different liabilities in different jurisdictions. Make sure you put them on record that you're the living man, flesh and blood. Living woman, living soul. You are not the corporate entity that has corporate rights. But really no true ones. But I just want to make that distinction. So people got to know. How do we do that? I would never put 1-308, but sometimes you might have to. But if you do, make sure you know how to argue it. I'm not saying it's bad or it's not. I'm not saying anything. I don't offer legal advice. We do not offer legal advice. None of that. Last section. Let's go banking. Yeah, that'll be good for the day. So banking. The trustee may open any business checking account, financial account, trust account, etc., which he is authorized by declaration to open, but he must keep in mind that by doing so, the trust will be participating directly in the unincorporated interstate banking association with all its limited liability consequences described above. There is only one type of account that avoids those consequences, the non-interest bearing checking account. When utilized in conjunction with the following banking practices, the trust and the trustee will remain out of tentacles of public policy. Basically, look here. Because, like, some of you guys are going to build trust credit, and that's not a bad thing. Don't let this scare you. It's just giving you information. Use the trust to open a bank account, and then don't hold certain things in that trust. Create another trust and hold the other things with it, and don't have a bank account with that one. That's important. And then you can make that trust a benefit. Man, look here, it runs so deep. Because, yes, a trust can be a trustee of another trust. Or it can be the beneficiary of another trust. Yeah, the wormhole runs really deep. A lot of people don't realize that, though. But let's keep going. Unless the trustee intends to play within the system, the trustee should never contract for any credit cards. Boring. And if the trust has already obtained them, rescind and cancel the contracts. Open a non-interest-bearing checking account in order to avoid the privileges and immunities associated with the interest. 148. It should be noted that proof of the operation of law in the manner described in the preceding section is that banks are not required to obtain a social or tax ID number and may accept any kind of identification they wish, only when opening non-interest-bearing accounts. And that's because if they... Let me keep going. Maintain the minimum required balance at all times if possible, and unless specified transactions demand otherwise. When transacting business, use that bank account solely for depositing the checks and keeping track of the trust funds. Never send or allow trust checks to be sent across state lines. Yeah, but no, but yeah. But no, but yeah. Instead of writing checks, use postal money orders or the bank's corporate certified checks or corporate money orders when sending interstate payments. And I'm going to fight that one. I haven't fought with a lot of information here. I'm going to fight that one. Just from the pure fact that if you're using a postal money order, because a lot of people don't realize the post office has been around since the Bible. But there's two post offices. There's there's the postal office, and then there's the corporation one, and then there's the private one. This is talking about using the public corporation postal money order, which when you do that, that's the United States corporate jurisdiction still. So that will pull you underneath that. Now, could you pay with that? I mean, this is literally grain of salt type stuff. In my opinion, if I'm wrong, someone tell me. I don't attribute it to the Private Express Trust. I attribute it to my stupidity and ignorance. But yeah, that one's a little nitpicky, if that makes sense. And use a bonded or non-bonded agent to establish the account on behalf of the trustee. When opening the bank account, non-interest bearing as well as any other, the following must be provided. The original notarized letter of authorization, a copy of the certificate of trust, a copy of the trustee appointment, a copy of the settler's acknowledgement of trust or letter of introduction. There are usually 2 introduction or acknowledgement documents per trustee. One regarding his fiduciary powers, I mean his responsibilities to the trustee, not to the trustee, the beneficiary, specifically addressed to the banking institutions, and one regarding his general power to establish all accounts, which is in the form of a banking resolution. I don't want to say this is outdated, but you can be a little bit more efficient. And a copy of the first and signature pages of the Declaration of Trust. The bank will always require evidence of a trust agreement, but the other documents may be sufficient depending on who you are dealing with. That's why you make a certification of trust. You don't have to necessarily give them the declaration of the trust. If you can open the account without providing these documents, or providing only a few of the documents, great. Again, this is a non-interest bearing checking account, so such scrutiny is not a priority. Accounts such as this have been downplayed by banks via advertised interest rates, so most people would rather open accounts that appear to have the prospect of interest earnings, even though they're not giving you jack squat on that. And then, only if necessary, to obtain an EIN, a copy of the IRS filed IRS SS4. This is outdated. It would not be the SS4. It would actually be the confirmation from the IRS that you have already received an EIN. Otherwise, most probably won't open it up for you. Just speaking from experience, not legal advice or anything of the sort. We're friends with the IRS. We don't, that's, again, you guys are talking about that tax nonsense. You guys got to go on somewhere. you're about to get people hurt. Um, unless you know what you're doing, which there are a couple people that know what they're doing, but they're doing it legally, not yeah. Continuing. Uh, and there's ways to get public. Sorry, I was about to say public and private. And there's ways to get foreign EINs as well. There's ways to yeah, it's yeah. There's ways to get foreign EINs, and if you're looking for that, let us know. Um, but yeah, take into account the state of ignorance of the law which prevails in America today. Give only the information needed to open the account, but do not arouse suspicion or fear from lack of understanding on the part of the bank employees, aka the lemons. They don't know. Like they're normal everyday Joes. They don't just be chill. Don't go in there talking about this is my constitutional right, this and that. Just ask if you're getting a hard time, just go ask for the manager. Ask for the manager. If you are able to befriend someone in the institution who can establish the account more flexibly, then do it. You must be shrewd in your methods for establishing the account, since regardless of which bank you choose, you will be dealing with trained employees who usually are just a few screws and bolts away from being robots. You should consult the business tactics of successful negotiators who will all attest that the individual who needs the service is at the mercy of the provider, but the individual whose confidence and attitude subtly conveys that his business is in high demand is given services, gifts, perks, not to mention any kind of account, just to get his business. It is not my intention to state the obvious, for in all business dealings, which a bank account is, one must be persuasive to get the desired results. And don't be hesitant to shop around, negotiate, bend perception, create competition. In the event it becomes unavoidably necessary to the opening of a non-interest bearing account, or if the trustee does see fit to obtain an interest bearing or other financial account, then he or an agent must apply to the IRS for an EIN for banking purposes. This may be done in one of the following ways. And I'm not going to read all of that, but there's a way. Yeah, we don't offer financial legal advice, but if you're having issues, um, please reach out. That's all I will say. Um, the form should be filled out according to the specifications of the trust. I have provided an example of how it has been filled out with a problem. Without a problem, it should be noted that due to recent changes in the online application, we're not going to read that because that doesn't necessarily apply. We don't want to do it online. We want to call that in. Um, with both telephone, this last part, we're about done. Pretty straightforward. With both telephone and online applications, the trust will immediately be given a temporary EIN to the hard copy application. Yeah. EIN is valid 24 member. Yeah, 24 hours. Yeah, this is pretty all straightforward. Just talking about the EIN number at this point. Um, yeah. I mean, that's pretty much it. We're pretty much done with this. Made some good strides in this document. We got transferring assets. We got jurisdiction. This transferring assets part next is good. Issuing bonds and certificates, keeping trust minutes, prevailing in legal affairs, because we're talking about jurisdiction here. And then that's it. The conclusions after that, and then that's it. Sorry. Proper IRS relationships, and then conclusion. Like, we're about at the end. I think we might have two more parts in us, and then we'll be on to the next document, which this has been fun so far. Um, hopefully this has been helpful for you guys. If you have any questions or any concerns about anything, please do us a favor and reach out on Instagram. Like, share, subscribe. But yeah, we enjoy doing this, and if you need anything, please don't hesitate to reach out. With that being said, adios.